Hello and welcome from my side to the section The German Supply Chain Due Diligence in Practice. First of all, a brief introduction of myself. My name is Luis Wanking and I work as a lawyer at the Düsseldorf office of Taylor Wessing in Germany. Taylor Wessing is one of the leading full-service law firms in Germany, meaning that we offer our clients legal advice in all legal fields. As a member of Taylor Wessing's commercial agreements and distribution practice area, I advise clients on the German Supply Chain Due Diligence Act, which is at least similar to the European Corporate Sustainability Due Diligence Directive, or shortly CSDDD. Therefore, today we will take a look at the mechanism and implementation of the German Supply Chain Act in order to provide guidance for implementing the requirements of the CSDDD. So, what points do we want to look at today? Basically, I would first like to give you an overview of the main differences between the German Supply Chain Act and the CSDDD. We will then take a look at the specific requirements of the German Supply Chain Act. Finally, we will briefly summarize and consider how the first year of the German Supply Chain Act has gone. First of all, let's take a look at the difference between the German Supply Chain Act and the CSDDD. In principle, the scope of application is very similar. Under both the CSDDD and the German Supply Chain Act, only companies that generally have at least 1,000 employees fall within the scope of application. However, the German Supply Chain Act only applies to companies that are located in Germany and that are reaching that threshold. According to the CSDDD, companies that are established under the law of a member state can fall within the scope, provided they have at least, as in the German Supply Chain Act, 1,000 employees. In addition, the CSDDD is based on a further characteristic, meaning the number of the worldwide generated turnover, which is at least 450 million euros. The German Supply Chain Act does not provide for this additional threshold in relation to turnover. It applies regardless of turnover if the employees threshold, which is 1,000, is reached. In addition, companies outside the EU also fall within the scope of the CSDDD if they generate a turnover of at least 450 million euros in the EU. In comparison, it can therefore be seen that the CSDDD has an extraterritorial reference beyond the EU. Furthermore, there is a special provision under the CSDDD for companies that assign franchise rights. If a company assigns franchise rights to self-employed persons operating in the EU and thus generates a turnover from at least 22.5 million euros with license fees, and a total turnover of 80 million euros worldwide, the company also falls within the scope of application of the CSDDD. There's also the possibility of attribution if the company is a parent company of a group of companies that exceeds the thresholds, the thresholds of 1,000 employees or 450 million euros turnover, when consolidating the employees and turnover of its subsidiaries. However, the German Supply Chain Act also provides for this possibility of attribution. The CSDDD provides for a gradual expansion of the scope of application, as can be seen on this slide. This means that not all companies will fall directly under the scope of application, or not immediately under the scope of application, but the thresholds will be gradually lowered. From 2027 at the earliest, the first companies with at least 5,000 employees and a turnover of 1.5 billion euros will fall within the scope of application. These thresholds will then be lowered, so that will then be lowered until 2029, when companies with at least 1,000 employees and a turnover of 450 million euros will fall under the CSDDD. This gradual expansion of the scope is also known from the German Supply Chain Act. This is because the German Supply Chain Act initially only applied to companies with at least 3,000 employees, and after this the threshold was lowered in 2024 to companies with at least 1,000 employees. Furthermore, the CSDDD is not already directly applicable. As it is a European directive, the contents of the CSDDD must first be imposed into national law or transposed into national law. The member states have 2 years to do this following the publication of the CSDDD in the official journal of the European Union. The CSDDD has not yet been published in the official journal of the European Union, but will be published until the end of 2024, and therefore the member states will have time until 2026 to transpose the content of the CSDDD into national law. However, the provisions of the CSDDD will not apply before 2027, as the CSDDD says that the provisions shall only apply 3 years after entry into force of the CSDDD. So, as the directive still has to be transposed into national law, and there may still be minor changes. German companies are currently still monitoring the development of the CSDDD and the provisions of the CSDDD, and as soon as the directive will be transposed into national law, and the final effects are clear and sufficient, companies will take a closer look on how to implement the provisions of the CSDDD. Therefore, EU companies and non-EU companies are currently still on the same level regarding the implementation of and requirements of the CSDDD. This slide summarizes the main differences between the German Supply Chain Act and the CSDDD. Basically, the term supply chain is defined more broadly within the CSDDD. The CSDDD also refers to direct and indirect business partners in this context. However, the German supply chain uses the phrases direct and indirect supplier with regard to the supply chain. Different terms are therefore used here, which we come back to in a moment. The CSDDD and the German Supply Chain Act also take different approaches to determine the specific due diligence obligations. Both the CSDDD and the German Supply Chain Act oblige companies to take action in the event of human rights or human rights and environmental risk. However, the measures must always be assessed in terms of what's actually possible for the specific company. This means that nothing impossible is demanded from companies. The CSDDD and the German Supply Chain Act provide slightly different standards for determining what is reasonable for companies. In addition, the CSDDD also provides for the possibility of civil liability, which is a key difference to the compared to the German Supply Chain Act. However, this does not mean that companies are held liable for every violation or for every risk within their supply chain. For example, they are not liable if a supplier on its own violates applicable occupational health and safety laws. Instead, the liability only applies if the company becomes aware of such a violation or such a risk and fails or still fails to take remedial action or remains inactive. This means that, as I said before, companies are not held liable for every breach in their supply chain, but only for the fact that they remain inactive. This also applies to the possibility of imposing financial penalties under the CSDDD. So there will be no financial penalties only because there was a human rights risk or human rights violation within the supply chain of a company, but there will be or might be financial penalties imposed if the companies doesn't react to this to the violation occurred. However, the possibility of imposing final sanctions also exists under the German Supply Chain Act with the same mechanism. But we will come back to this later during this presentation. Another key difference is that the CSDDD places a greater focus on environmental protection. On the one hand, by requiring more environmental rights to be observed, but also by obliging companies to draw up a plan on how they intend to meet the goals of the Paris Climate Agreement. The German Supply Chain Act does not spend that much focus on the environmental rights, as we will see in the following. So let's take a look at the different terms of the supply chain. According to the German Supply Chain Act, only the activities of the company's own business area and the activities of their direct suppliers need to be considered in general. Direct suppliers are all suppliers with which the company that falls under the scope of the German Supply Chain Act has have a direct contractual relationship. Direct suppliers in the upstream and the downstream area are included. The due diligence obligation must therefore always be fulfilled in relation to them. The German Supply Chain Act applies a very broad standard in that, for example, suppliers that have no connection to the product of the company in scope, or has no direct connection to the product of the company in scope, have also have to be considered, and there are no exceptions for that. So every direct supplier has to be considered under the German Supply Chain Act. This is different compared to the CSDDD. The CSDDD generally covers direct and indirect business partners in the upstream sector. This means that, in principle, the CSDDD covers a majority of suppliers compared to the German Supply Chain Act, as under the German Supply Chain Act, indirect suppliers have only to be considered in cases of substantial knowledge. Substantial knowledge means that the company in scope has knowledge that there might be a violation at a indirect supplier. However, the CSDDD contains the restriction that only those direct or indirect suppliers are to be considered that are also connected to the specific product of the company that is in scope of the CSDDD. This means that, for example, suppliers which supplies food for the canteen or other office stuff don't need to be considered within the CSDDD, as these suppliers are not relevant for the product of the company that is in scope. In addition, the downstream sector is limited to direct suppliers which carry out activities related to the distribution, storage, or transportation of the product of the company that is in scope. As a result, the CSDDD provides for a broader definition of the supply chain. However, this broad definition can be limited in practice by the characteristic of the product relatedness, as I said before. There's also another possibility of restriction due to the different approach of the CSDDD and the German Supply Chain Act. This is because the starting point in each case under the German Supply Chain Act as well as under the CSDDD is the risk analysis, in which companies have to analyze which suppliers are especially risky. So the risk analysis under the German Supply Chain Act takes a supplier-driven approach, meaning that all direct suppliers and where there is substantial knowledge, indirect suppliers have to be considered and included. This means that possibly a large number of suppliers have to be included. This is different for the CSDDD. On the one hand, some suppliers are already excluded due to the lack of relevance for the respective product, as I said before. And in addition, the CSDDD only requires suppliers to be considered where negative impacts are particularly likely, or should they actually occur, are particularly serious. The CSDDD therefore takes an impact-driven approach in that the due diligence obligations only extend to those suppliers where negative impacts are particularly likely or particularly serious. As a result, this may mean that despite the broader definition of the supply chain compared to the German Supply Chain Act, fewer measures need to be taken with regard to suppliers under the CSDDD. It is therefore also possible to exclude suppliers using this impact-driven approach under the CSDDD. So, in the following, we will take a closer look at what the German Supply Chain Act requires and how this could initially be implemented in practice. It should be noted in this regard that there is still no best practice approach, since the German Supply Chain Act has only entered into force in 2023. So now that we have already discussed the main differences, here's an overview of what the German Supply Chain Act requires of company within its scope of application. The German Supply Chain Act requires companies to respect human and environmental rights along their supply chain and within the company itself. The German Supply Chain Act is based on a total of 12 human rights, and basically which are based on several international conventions and or the ELO core labor standards, and as well as national law. For examples, the ban of child labor is included, or the general principle of equal treatment. To a minor extent, as I said before, environmental risks are also included, although these play a subordinate role within the German Supply Chain Act. In order to address these human rights and environmental risks, the German Supply Chain Act obliges companies to fulfill a total of 9 due diligence obligation, which is establishing risk management, naming internal responsibilities, carrying out a risk analysis, issuing a policy statement, taking preventive and remedial action or remedial measures, establishing a complaint procedure, and where necessary, taking measures towards indirect suppliers, as well as documenting and reporting on the fulfillment of the due diligence obligations. The risk analysis is particularly important in this regard, as it determines the starting point of the fulfillment of the due diligence obligations. The risk analysis is, for example, if no risks are identified within the risk analysis, the German Supply Chain Act does not require further measures to be taken. This is also done against the background that companies should not be put under unnecessary pressure or unnecessary strain. As risk management and risk analysis are therefore very important, we will now take a look at how this could be implemented in practice towards suppliers. One approach for carrying out the risk analysis and developing an action dashboard for direct suppliers would be to set up a basic Excel file for this purpose, in which you document the risk analysis. This is what you could especially do if you don't want to use an external solution by a service provider. At the beginning of this implementation via an Excel file, you should create a list of all active suppliers. This list should first of all contain as much data as possible. For example, the data collected in there could be the address data of the supplier, group information, order volume from the supplier's point of view, and other aspects. This list should also contain product-related information. One approach here could be to collect information on the product category, the product, further product details, and the production location where the concrete product is produced. You could also consider including upstream suppliers, if known to you, as the CSDDD, as we had before, in particular will require upstream suppliers to be recorded anyway. On the basis of this collection of information, you could then get a first overview of your own procurement structure, as shown here on the right of this slide, either on the basis of an organization chart or, for example, on a world map, just to map your suppliers. Based on the created list of active suppliers, you move on to the second step, which is called under the German Supply Chain Act risk identification. According to the German Supply Chain Act, the idea is to first carry out an abstract and then a concrete risk analysis. The abstract risk analysis means that you first assess, on the basis of country risk and industry risks, whether or not there's a specific risk or problem with your individual supplier. And only if there might occur an abstract risk, you spend further attention to this concrete supplier by conducting a concrete risk analysis. This means that you already have an initial filter at this point to sort out suppliers that are located in an unproblematic country, for example Germany or even South Korea, or an unproblematic industry. In other words, these suppliers do not need to be included in the next step, and you could reduce the amount of the suppliers that need to be subject to the risk analysis. So how can such an abstract analysis be carried out? One possibility is, as I said before, to carry out the abstract analysis by using country indices. As you can see on this slide, various country indices are used for this. For example, but not mandatory, the IGB Legal Index or Environmental Performance Index. And compare these with the respective location of your supplier. The indices have different scores depending on the country. The higher the risk of human rights or environmental violations in the specific country, the lower the score. The idea is then to enter these scores or values into your Excel spreadsheet, and considering the individual scores, determine an overall value in order to show whether the supplier is to be considered as abstractly at risk only because of its activities in a certain risk country or a certain risk industry. Suppliers for which there's only a low or even no risk concerning the abstract country or industry risk, these suppliers don't need to be considered in the next step, the concrete analysis, meaning that suppliers are already filtered out. The suppliers for which there are abstract risks are then looked, as I said before, again concretely. For example, on the basis of self-disclosures or past experiences. Again, as you assign values for on the basis of the self-disclosures or the past experiences and enter them into the Excel template. The results from the abstract and concrete analysis are then combined and divided, for example, into suppliers with a high, mid or low risk, high, medium or low risk. If after the concrete analysis you conclude that there's no risk at all, these suppliers can also be filtered out. The idea is, or it can be filtered out, and no measures have to be taken under the German supply chain act towards these suppliers. The idea is to be able to say at the end which suppliers are particularly risky and which are not. In the next step, identified concrete risks can be prioritized. This is because the German Supply Chain Act does not require all risks to be addressed immediately. Instead, companies are only obliged to act within the scope of their own capacities. As I said before, companies shall not be put under unnecessary pressure or strain. Nothing, or to summarize it, nothing impossible should be demanded from companies. The German Supply Chain Act is based on 4 different factors for this prioritization: type and scope of own business activities, own capacity to influence, severity of a potential violation, and own contribution to causation. You can see this criteria highlighted on this slide in blue. You could then rate out of a scale from 1 to 10, for example, your own ability to influence the supplier where the risks that you identified during the abstract and concrete analysis occurs. For example, the greater your own turnover is in relation to the supplier's turnover, the greater the influence you will probably have on the supplier, as you would be considered a major customer of this supplier. The aim should be to make plausible consideration and set these in relation to the specific risks identified in order to prioritize how urgently the specific risks need to be addressed at the supplier. Depending on how the individual prioritization criteria are assessed, it might be possible that although the concrete risk is assessed as low or priority as low, a priority of high may result because, for example, you have a higher influence on the supplier, or a possible breach is considered serious. However, it is also possible that although a medium concrete risk has been identified, this does not need to be addressed further initially, as there's only a low level of influence. This is shown on this slide by a priority of low. So, as you can see, and as I said before, under the German Supply Chain Act, companies are only obliged to act and take measures if this complies to their own capacity. Once risks have been identified, weighted and prioritized, specific measures can be planned based on the prioritization. These individual measures could also be listed in the Excel template as part of a measures dashboard, or to develop a measures template, to develop and monitor a measures dashboard. Various measures are possible in this regard, whereby the scope of measures will also depend on the prioritization. Where a high priority is assumed, more comprehensive measures will also be required. This could include, for example, and as you can see on the slide, agreeing a code of conduct, a second self-disclosure, audits, training, or if breaches actually occur, drawing up a corrective action plan. Monitoring could also be planned in cases of violations. Where the priority for action is low, simpler measures can be implemented, such as agreeing a code of conduct or obtaining a further self-disclosure. this could also be sufficient in this regard, especially if the supplier was only identified and prioritized with a low risk and a low action priority. So during all of these steps, it is important to document the individual steps and to be able to prove why measures have or have not been taken. Once again, the German Supply Chain Act does not impose sanctions if risks or violations occur along the Supply Chain Act. The German Supply Chain Act only penalizes companies that do not address the shortcomings in the supply chain and remain inactive. So planning or conducting the risk analysis appropriately and taking appropriately measures is a central point of the German Supply Chain Act to avoid penalties. So this brings us to the last point of this presentation, in which we want to take a deeper look at the controls and sanctions in the first year of German Supply Chain Act that have been imposed on German companies. The competent authority in Germany, the so-called BAFA, published a press release in December 2023 outlining the consequences of the first reporting year. According to this, a total of 486 inspections were carried out in 2023. The majority of the inspections covered companies from the automotive sector, chemical sector, pharmaceutical sector, mechanical engineering sector, energy, furniture, textile, and food industry sector. Additionally, the BAFA received 38 complaints via its own complaints procedure. Although the BAFA said that only 20 of these complaints were in fact related to topics of the German Supply Chain Act, so meaning on environmental, on human rights and environmental topics. In the further course, the BAFA therefore contacted companies only in six cases as a result of these complaints. The feedback from the companies revealed that the companies are dealing intensively with the complaints and are in contact with their suppliers to whom the complaints relate and are working through the problems. Two cases from the automotive sector and the food industry were particularly well known from media coverage. Large German companies in the automotive sector were accused of using forced labor to manufacture their products. Supplier of the well-known companies Volkswagen, Mercedes, and BMW saying that suppliers of the well-known companies, as I said before, Volkswagen, Mercedes, and BMW, would come from the province of Xinjiang in China and employ the Uyghur minority there under forced labor. The German car manufacturers would therefore in turn profit from this by installing parts manufactured under forced labor in their own products. Another case that occurred was that large German supermarket chains such as Edeka, Rewe, and Lidl have been accused that suppliers of them were violating health and safety regulations on a massive scale on plantations in Spain, Ecuador, and Costa Rica, and that Edeka, Rewe, and Lidl were profiting from this. For example, one supplier in Ecuador is said to regularly use pesticides in its plantations without the workers there having the appropriate protective equipment. As you can see from this slide, and as I already said before, the complaints about forced labor and violation of occupational health and safety, for example, have received massive attention in the public press in Germany and have been widely reported. However, to emphasize this once again, the BAFA has, although these complaints have been a massive topic to the public press, the BAFA has not yet imposed any sanctions despite these complaints and the public perception. This is because, as I said before, the companies concerned have taken action, which means they have entered into discussions with suppliers and taken measures, and they did not remain inactive. So the German Supply Chain Act is aware that violations or risks can occur and cannot be avoided in any case. It only intervenes and imposes sanctions if violations or risks occur due to inadequate measures on the part of the company, or if the company simply does not spend attention to the violation or the risk within its supply chain at all. And this is what the CSDDD says as well. The CSDDD doesn't want to impose sanctions on every company for every violation within the supply chain, but want to impose sanctions on companies that just don't care, although there might be knowledge of these violations. So, to summarize this presentation and to take away some key elements with respect to the comparison of the German Supply Chain Act and the CSDDD. Sanctions only take effect if you do not adequately fulfill your own obligations, not in the event of a violation along your supply chain. Even if violations occur, this does not necessarily mean that sanctions will be imposed. Instead, as a company, you have this in your own hands by taking comprehensive measures once you become aware of violations or risks. And to say, the better the measures you take, or the better the measures you design in advance during the implementation of the CSDDD or the German Supply Chain Act, the better the transparency along your supply chain, meaning that you know which kind of your suppliers might be considered particularly at risk. The better you will be able to take measures in the case that there will occur a violation, and this does exclude liability risks. With regard to the CSDDD, there's still enough time to establish such measures and processes for your own company. This is because, as I said before, the CSDDD will not apply before 2027. This is also, or can be seen in the consulting practice today. European companies have not yet started with the actual implementation with respect to the requirements of the CSDDD, but are still evaluating their own existing processes and how these can be adapted to the requirements of the CSDDD. In addition, small changes are still possible as long as there's no transposition international law, which is required by 2026 at the latest. And just to conclude this topic, and which can also be seen from the practical advice within the German Supply Chain Act, yet no company is perfect from the outset. Implementation will take time, but at least the German authorities competent for the German Supply Chain Act are taking this into account within the framework of the German Supply Chain Act. It is not expected that there will be not a single risk or violation along the supply chain right from the start. But it will be expected that companies will try to comply with the requirements and will implement specific processes to avoid such violations and risk along the supply chain. So all in all, these points should be taken away as a key takeaways from this presentation and in consideration of previous experience under the German Supply Chain Act. If you have any further questions, please just feel free to contact me via email. And I hope that I was able to give you at least a short overview on the German Supply Chain Act and the progress in Germany, how the requirements of the German Supply Chain Act and the CSDDD are implemented right now. And yes, that's it from my side. Thank you for your attention.